Hello friends, how are you? I hope you all are good. So, in this part, we will talk about conjugal rights, judicial separation, divorce, custody, maintenance, and appeal. So, now let's start. Restitution of conjugal rights. It has been defined under Section 9 of the Hindu Marriage Act 1955. When a spouse left the company of the other without any reasonable excuse, the aggrieved party may apply for restitution of conjugal rights before the family court by way of a petition. The burden of proving reasonable excuse for leaving the company of the other shall be on the person who has left the company of the other. In the case of Vedantam versus Virmala, it has been said that when a petition of Section 9 of the Hindu Marriage Act 1955 is pending before the family court, Section 24 of the Act 1955 can be invoked automatically for grant of interim maintenance. In the case of Sumitra Devi versus Narendra Singh, it has been said that Section 9 of the Hindu Marriage Act 1955 is not violative of Article 19, Clause 1, Subclause G of the Constitution of India. Judicial separation. It has been defined under Section 10 of the Hindu Marriage Act 1955. A spouse may present a petition praying for a decree of judicial separation on any of the grounds specified in subsection 1 of Section 13, and in case of a wife, on any of the grounds specified in subsection 2 thereof. And where a decree of judicial separation has been passed, it shall no longer be obligatory for the petitioner to cohabit with the respondent, but the court, if it considers just and reasonable, may rescind the decree of judicial separation on the application by petition of either party. In the case of M. Narasimha Reddy versus M. Busamma, it has been held that judicial separation does not put an end to the marital status of the party. Divorce. It has been defined under Section 13 of the Hindu Marriage Act 1955. Any marriage solemnized may be dissolved by a decree of divorce on a petition presented by either party, the husband or the wife, on the ground that the other party has, after the solemnization of the marriage, had voluntary sexual intercourse with any other person other than the husband or wife, or treated the petitioner with cruelty, or deserted the petitioner for a continuous period of not less than 2 years, or ceased to be Hindu by conversion to another religion, or been incurably of unsound mind or suffering from mental disorder, or renounced the world by entering any religious order, or been suffering from venereal disease in a communicable form, or not been heard as of as alive for a period of 7 years or more. In the case of Pawan Kumar versus Mukesh Kumari, it has been held that if the wife was pregnant from some other person at the time of marriage, it would amount to cruelty and mental agony to the husband. Either party to marriage may also present a petition for the dissolution of marriage by a decree of divorce on the ground that after passing of a decree for judicial separation, cohabitation has not been resumed between the parties to the marriage for a period of 1 year or more, or after passing of a decree for restitution of conjugal rights have not been restored between the parties to the marriage for a period of 1 year or more. And when, if the petitioner to the divorce petition is the wife, the additional grounds are also available to her for the decree, which are as follows. Before the commencement of the Hindu Marriage Act 1955, the additional grounds are before the commencement of the Hindu Marriage Act 1955, if the husband had married again and that other wife is alive at the time of the presentation of the divorce petition, or if the husband since the solemnization of the marriage has been guilty of rape, sodomy or bestiality, or the wife has been ordered or decreed the maintenance in maintenance case and the wife was living apart and cohabitation has not been resumed between the parties for 1 year or more, or the marriage was solemnized before the wife attained the age of 15 years and she has repudiated the marriage after attaining that age but before attaining the age of 18 years. In the case of Naveen Kohli versus Neelu Kohli, it has been held that by the Honorable Supreme Court of India that irretrievable breakdown of marriage is not a ground recognized by law for the grant of decree of divorce. Under Section 13A of the Hindu Marriage Act 1955, the alternate relief in divorce proceedings may be considered by the court and pass a decree for judicial separation instead of divorce. Divorce by mutual consent. It has been defined under Section 13B of the Hindu Marriage Act 1955. If the husband and the wife have been living separately for a period of 1 year or more, and both have mutually agreed to dissolve the marriage, two motions have to be filed for the divorce and between both the motions 6 months gap should be there, but second motion should be not later than 18 months from the date of first motion. In the case of Amardeep Singh versus Harveen Kaur, it has been held by the Honorable Supreme Court of India that 6 months period in Section 13B2 is not mandatory but directory and it may be waived off after considering the facts of the case. In the case of Rajat Gupta versus Rupali Gupta that has been passed in 2018, it has been held by the Honorable High Court of Delhi that if any term of the settlement arrived between the parties has been breached by any of them, he or she would be punished for contempt or punished as per the law. Under Section 24 of the Hindu Marriage Act 1955, either wife or husband may file an application for entry maintenance, and under Section 25 of the Hindu Marriage Act 1955, either party may file an application for permanent maintenance and alimony. Under Section 26 of the Hindu Marriage Act 1955, either husband or wife may file an application for custody of minor child or children. Lastly, under Section 28 of the Hindu Marriage Act 1955, either party may appeal against any order or decree made by the family court. Thank you. Jai Hind, Jai Bharat.